Okay, Jordy's just getting a little feedback and it's going to, Jordy, are you able to get on the line?
I'm here. Can you hear me?
Okay.
Somebody's got their, I think if everybody could just mute their microphones because I'm getting some feedback from somebody who's hearing us and then Great. That's better, I think.
Yeah.
Morning.
We have a couple of people haven't muted, but when they can, please do. And away we go. Okay, so Jordy, today's a big day to discuss the recent changes in the legislation that came about on April 7th, thanks to the hard work of the Attorney General's office. And I say that sincerely because you and I were both involved with the project. They moved this along in legislative terms in lightning fast speed. I thought we could start today, and then we'll come to some of the specific questions. I thought we would start today with walking through the legislation and more particularly going through what is it going to mean to do a video execution of a will. And if you wouldn't mind, we'll start with my first question is, Jordy, all right, so what is the legislation saying in terms of the new rules?
Great, Ian, thanks, and welcome everybody. Good morning. I hope everybody's doing okay and safe and healthy. So I put up, hopefully you can see on my screen share, I put up a copy of the emergency order. So this is the order that the Attorney General and the Cabinet enacted, excuse me. And they took the approach that I think good is better than doing nothing at all. It's not a perfect solution, of course, but so basically, first of all, it's for the duration of the emergency. So this is not necessarily going to last post the emergency. That's the first thing. Second of all, it is not retroactive. So if you did anything that would now be allowed before this order, it probably is not valid. But what the order says is that when the Act, the Succession Law Reform Act, talks about being in one person's presence, that is now satisfied by audio-visual communication technology. So the way we interpret that, I guess, is a Zoom type call, because audio-visual communication technology is defined to be an electronic method of communication in which participants are able to see, hear, and communicate with each other in real time. So I'm certainly going to use Zoom and have used Zoom to meet this. So that's the first thing. And the second key component of this is that at least one of the two witnesses, if you're going to do it by video, so this only applies to if you're doing it by video, has to be a lawyer or a member of the a licensee within the meaning of the Law Society Act, which I take to be a lawyer, or I guess certain paralegals. And so that's what the legislation says. It says that for wills, and there's a similar provision for powers of attorney that witnesses have to be in the presence of the grantor of the power of attorney, and so the order covers that as well. So, and just maybe, Ian, if you can let everybody know that all of this stuff that we're going to pull up is on your website, on the Hull and Hall blog.
Absolutely. We've got a COVID-19 resource page that it's on the front page of our blog and sorry, of our webpage, and it takes you right to this page that Jordy's called up. And all of these resources are on this page. We've tried to just isolate, it's a good word, isolate the blogs that specifically relate to COVID-19 matters, and you can see it there. So that's, Jordy, if you don't mind working through it allows people, if they want to go onto our website, and you can go right to the documents right now, if it's easier for you to use them, or sorry, to see them, and also just to see what we're talking about. All right, so Jordy, now that we've got an idea of the legislation, there are rules, of course, for wills and powers of attorney in respect of execution by video. And I've got one this week I'm lining up, and I know you've already done one. So let's start talking through the process, what's going to be involved from start to finish. and using your checklist to help us follow it through.
So, so Ian created this will execution by video checklist that that I used in my first. I did my first one yesterday at 12:14 p.m. with my son Spencer watching, and I used this checklist that Ian created, and to some degree, and I'll tell you sort of what I did, and but it's important, I think, because this is so novel, that we use some sort of methodology for this. I think we're, you know, we didn't, obviously the order does not specifically say what the process is for how to do what we're now allowed to do. And so, so this is, I followed this process, and just to remind us of what we have to do. And so, you know, obviously taking down the witnesses' names, and making sure that they're not a beneficiary and not a spouse of a beneficiary for a will, and confirming, just so we all know, that one of those witnesses is an LSO member. So there's a spot there I see Ian put in for that. And so this is, as we see it, the process would work something like this. Maybe an overview of the process isn't a bad idea. So the first thing is that the testator gets a copy of the will that they're going to sign. And a couple things that I've just implemented is I'm putting the name of the document, so the path and the time and date that it was generated, right in the footer of the document automatically, so that I can make sure that the testator is working off the same document that or signing the same document that they're supposed to be signing. And I think that'll also be helpful to track it, to make sure that we're all signing the same document. So if you can insert the path, and you can do that in a Word document pretty easily, in the footer with the document name and the date and time. So the first thing is to confirm that the client's got that. I actually sent the client this checklist so they knew what we would be doing in advance. And then we arranged for the Zoom call. And so we all joined the Zoom call and confirmed that we could hear each other and see each other. That's numbers 3 and 4. And then I got the consent, as we do when we're recording, that we can do that. And turned on the recording. Then I just confirmed the date and time, although if you're not recording it, you know, it's very important, but otherwise if you have the date and time, you should know that, but I put it in there. And then I just had everybody identify. I was acting for a couple, and so I just had them identify, oh, I'm John Smith, I'm Susan Smith, great, thank you. I had their ID, so I didn't, and I had met them before in this case, so I knew who they were. I didn't ask them to hold up a piece of ID for that. And then I gave the instructions on what we were going to do. To be honest with you, this was a low risk kind of sort of mirror will, couple everything to each other, kids kind of thing. So I did not, you know, go through each page watching them initial each page, but what I did was ask them to confirm that they were looking at the will that I had given them and that they should be working and that we could see them. So my son sat beside me watching on video, we could see them, they could see us. And then I just had them initial the bottom right corner of each of the pages. I did not ask them to hold it up each time. I know that's in the checklist, that, but I just didn't feel that it was necessary. I mean, but I can see certainly in a higher risk situation where you would definitely want to do that. And then they initialed all of them, and I told them to wait till when they got to the last page. When they got to the last page, the date was in already, so I didn't need them to insert it. But I made sure that I could see them sign it. So I asked them, actually, their camera wasn't adjusted quite right, and so I wanted to be able to see them and the signature. So we fiddled around with that a little bit so that I could see them sign it. And they did that, and I asked them to lift up the last page that they had just signed and acknowledge that it was their signature in case we needed that down the road. And that's how I did it. And I confirmed that we saw it, and that was the process.
All right. So now that the wills were signed, what happens next?
Right. Well, here's a bit of the problem, because we couldn't subscribe as witnesses at that point. Of course, we don't have the documents. So
sorry, just can you stop there, the substantive point, because this is a really interesting discussion that's starting to happen because of the legislation.
Yes.
You were saying subscribe, and people are using the word counterpart and the possibility of counterpart, but I think you had some comments on the important legal distinction here of using the word subscribe. Can you just talk to us about that?
Right. So the requirements, right, are that the witness subscribe the will in the presence of the testator. That's the other. So there's the testator signing it in the presence of the witnesses, but it's also the witness subscribing in the presence of the testator. That's the second component of a will. Subscribing just means signing, in essence. And I don't believe, and I would defer to you, Ian, but I don't see how you could sign it in counterpart, i.e. you sign, as a testator signs one copy and the witnesses sign another copy that's not the one that the testator signed. I don't see how that works to be a valid will. But I mean, again, we're in brand new territory here. Obviously, it was never an issue before, but so I don't see it as a possibility. But I don't know if you had any thoughts on that. But.
Well, no, I agree 100%, and I think it was not dealt with in the legislation, and I think it's a stretch. I know certainly when the legislation was being discussed by a group of practitioners that were trying to assist the Attorney General with our input, the concept of counterparts was thrown around, and I think the element of the legislation, existing legislation, of it being the witness having to subscribe it in front of the testator eliminates the possibility of the counterparts clause. I don't think anybody anticipates that counterparts are operative, but that's the difficulty we have here. That being said, someone just asked a really interesting question, Jordy, and what happens if the testator dies between the time the will has been signed and it has been witnessed?
I don't think it's valid.
Yeah.
That's, I mean, it could happen also to the witness, right? I mean, then you'd have to re-sign it, I think. I think this is look, we're trying to do the best we can. The faster we can get things done, the better. I know in my case, my client signed what's yesterday, Friday. It's a long weekend. I'm going to have it on Monday. We're going to be on a video call on Monday to witness it, so it's official and valid at that point. I don't think it's a valid will until the witnesses subscribe in the presence of the testator.
Okay, so this is bringing out some good other questions. Now, we've got the testator signing it. Now we've got to get the witnesses to execute the document. As the Law Society describes it in some of their discussions, these are wet signatures. So we need another 2 wet signatures. As you say, it's imperfect if something like that, interesting question about someone dying, but it would be, and like you did with your son, but this isn't impossible. You could also have this with 3 different locations. But let's go to the scenario where the 2 witnesses are watching this. They've seen this testator sign the will. Yeah. They are going to get the will sent to them, back to them. And let's use your illustration. Over the weekend, Monday's the call. You've set up a call with whom, and what are the next steps?
So we arranged to have a courier pick up the will on Monday, because it was a long weekend, and deliver it to my house. So this is video conference number 2. So video conference number 1 was when the testator signed. Video conference number 2 is when the witness, at least the first witness, and maybe both of the witnesses if they're together, like we're doing in my case. So we're going to receive that will. That's the one with the wet signatures on it. And we're going to get on a Zoom call with the testator and basically go through that same process, making sure they can hear us, and that we can hear them. And I'm going to confirm the date and time of that, and then I'm going to record it. And then I'm going to have them watch me initial each page, and then my son initial each page. And then on the last page where they sign, I'm going to insert the date that I'm witnessing it. I think that's a good idea. Notwithstanding that the affidavit of execution will have that, I think it's important because remember, well, this is my guess anyway. I say remember. I'm hoping this is right, but that the will is not dated until is not valid until both witnesses subscribe, and so therefore, I think the date of the will is actually the date when the final witness signs in the presence of the testator. So that's why I'm putting the date in beside the signature, and so they're going to watch, and I'm going to sign it and lift up the page and say this is my signature and show them while they watch me sign. Then I'm going to give it to my son and have him do the same thing. And I think at that point, we now have a valid will.
Okay, so, and that's, I actually tend to agree, but there is maybe some controversy on whether the date of the will is the time that it is witnessed or the time that it is signed. And I guess we'll have to see how that unfolds. We're just seeing that a little bit of the discussion on the chat line here. And I agree, this is an imperfect situation and we're all doing our best, but I guess from your standpoint, and I tend to agree that the date of the will is the date that it has been subscribed in front of the testator. But we don't have any substantial compliance legislation right now and will not, I doubt, in the COVID period. So at this point, I think the best answer is, well, the safer answer might be that it's the date of the witness signing in my view. But that being said,
I don't know what the answer is to that. I think that's why it's not a bad idea to put the dates that it's witnessed right on the will so that the court can, that anyone looking at that document will recognize that. That may be confusing to other jurisdictions. If you're ever trying to, get an ancillary grant or anything else, perhaps we'll be giving, legal opinions to foreign jurisdictions on this. But so I think it's an open question. I don't know any research or any case law on that. I tried to find it, but I haven't found it yet.
Well, we'll have to see how this all unfolds, but I think there's room for debate here, and the chat channel is discussing it in an interesting way right now. So, okay, so now let's move on because the will has now been signed by the testator. Now the two witnesses. Now, can you just add another to this scenario? Of course, what happens if the two witnesses are not present at the same time when they witness the testator, but are present by way of video in two different locations?
Sure. So I think somebody may have written on my screen here because there's a green mark. I don't know if that's. I didn't do that. I don't think. But anyway, this is the conference number 3. So this would be if your second witness and is not in the same location as the first witness. And I would suggest that the second witness, the LSO member, be the one who witnesses it second, just because they have it in their possession at the end and can swear the affidavit, at least one of the affidavits. So it doesn't matter which order, but that's just what we've, I think, suggested. And basically the same process. So you get on video conference number 3 with the testator. The case law is pretty clear that you actually don't need the other witness to witness the second witness signing. It's really that the witness has to be in the presence of the testator. Doesn't necessarily mean that you have to be also in the presence of the other witness. If you can, you might as well. I would prefer to do that, but I don't think it's strictly required. And so you follow the same process that I said with the second conference, on video, initialing, signing, holding it up, and at that point you're done.
All right. So now when you say you're done, we're not quite done because we have to do an affidavit of execution.
Right.
So once we've got our witnesses done, we've got a valid will. There's some debate as to what day it's valid, but let's just take for your argument for now that it's valid now, it's effective. What do we do about the, you want to close the loop with the affidavit of execution?
Right. So this one is a bit of an issue because an affidavit of execution is a court form, and that's to make it easier for the court to issue probate in common form without having to worry about the form of the affidavit of execution. Did it say the right things, et cetera? So that's why we have a court form that just actually speeds up the probate process. But the current form 74.8 doesn't deal with this, right? Because it assumes that you're all in the presence of one another at the same time and not on video. So I'm just going to call up I think you guys came up with a couple of affidavits for this kind of situation. If anybody knows how to get rid of this green line that somehow got on there, let me know, but you can just send a chat message. But there's, as I see it, Ian, there's two witnesses, two affidavits of execution that are necessary. So one by the licensee of the Law Society. So this would be the lawyer's affidavit, confirming that they were in the presence of the testator and the other witness, and that they saw the testator sign it, and then the date that they then attested to and subscribed their name to the will, and that's paragraph 4 here. So that now we've confirmed that the testator signed in their presence and the presence of the other witness, that they're a licensee, and that they subscribed in the presence of the testator. And then we have some optional clauses if both witnesses were present at the same time. I think you probably could get away with one affidavit, but there's some options there for what to include. And then there's a second affidavit if by the non-Law Society member, confirming basically the same things.
So Jordy,
yeah.
just to jump in now, two things. One is I see the jury at the bottom. You've got it sworn, affirmed, or declared before me by video conference.
So that's, assuming you're going to have because I can't, if I'm the witness and the lawyer, I'm swearing this affidavit up here, I can't also commission it, which causes further problems because now I have to deal with having my affidavit of execution commissioned remotely as well.
Just so everyone knows, this is being recorded, and we'll be putting it up on our website. So if anyone's concerned about being able to follow some of this later, we are recording it. Okay, so so let's talk about the sole practitioner. This is a problem, right? Who would usually commission the affidavit of execution.
Right.
What are your thoughts beyond what you've just said?
Well, two things. One, I think that if in the usual situation we had one of the witnesses sign an affidavit of execution, and then the other witness, who was the lawyer, let's say, could commission that affidavit of the witness. Okay, that I think was allowed. So that's not the problem. You could, I think, commission the affidavit of the second witness. The problem being, I think there needs to be evidence that you're a licensee. Now, one of the witnesses was a licensee of the Law Society of Ontario. And who's going to swear that but the licensee? Probably. I guess you could try, I was advised by and verily believe. I think that's possible. We don't know. I think that's the other point here. These affidavits are not court form. They're format ones in the sense that they haven't been approved by the committee, by the government. So I think it's a great attempt at this, and I think it covers everything that you would want, but there's no guarantee as to the form of the affidavit that's going to be required by the court ultimately. I think what we were trying to do is gather all the, try to make it as close to the original affidavit, but still put in the evidence that we think we need to satisfy a court that this was done properly under the order, the emergency order. So that's, I think, important to understand that, we are sort of coming up with this without any confirmation, I guess is the point. But I think if you try to, maybe you could use one affidavit, I don't know, but maybe one option is one affidavit from the one witness that says, I am not a licensee of the Law Society of Ontario, but I verily believe that John Smith is a licensee of the Law Society of Ontario, and then do it that way. We don't, that's a thought. I prefer to have, I'd prefer in a perfect world to have two affidavits of execution, but depends what the court's going to accept, right? That's what we're into. And the sooner, I think if we stick with a standardized affidavit of execution and more people are using it, I think, I think that's going to be more likely to be accepted by the court, I think.
So a couple points, Jordy. So in some ways, don't you solve a bit of the problem when, like you did with your case, because you had the second witness was a family member at home, right? Right.
That's true. I could do it, and then I could probably just do one affidavit, just mine, but I still have the issue because the reason we have to say we're a licensee is that the court's going to require some evidence for this to be valid that one of the witnesses was a licensee of the Law Society of Ontario. That's required under the legislation, and so that's why we need that that statement. Now, again, could we have an affidavit that just says by the non-LSO member that I verily believe that the other witness is a LSO licensee? Is that going to be enough? I don't know. What happens if they're not a licensee? I guess is what the court could say. So how do we know that? But again, we're I guess talking about the best practices, I think, and you can modify it, I guess, based based on what we hope is going to work.
Yeah, that's for sure. And I just think, Jordy, I sent you a link. Sorry, I just emailed you an updated link page. We were asked by the Law Society last week to do a program on this, and some of the people watching this may have already heard it or watched it. It was a 2-hour program on not just this topic, but other topics. But one of the things that we included in that, and I've just sent you the most recent version of it, is a links page that the program.
Could you Slack that to me? Because I can't get on my email.
Oh, okay. I'll do that. And in this links page, what it did was it allows is that it set out a bunch of the resources that we're talking about here, and I'm just going to I'll send you that by Slack, and let's see if that worked. But from that standpoint, it's a tool that we tried to pull together. One of the things that the Law Society has done is they have actually, of course, taken some real time to assess. Oh, here we are here. Great. Someone's just put it on the chat line too. Taking the time to make some, they've taken the time to comment on this, and here we are here. Thanks, Robert, for putting that up. The thing is that what I like about it is that it has the virtual commissioning piece of it as well. So the two parts of this whole video processes involves now with the wills, but the video commissioning is also available, and the tools for that is one of the links there. So that was a long-winded way of saying there's another resource.
This is the Law Society's, and it's I think it's a free program. You can download it, and oops. Anyway, You can download it at the LSO store, and there's some resources there.
And the links as well. We'll put the links up on our webpage as well. These links, we'll put it as a separate resource link. Morag, I know you're listening, and if you could do that as well. Okay, so let's work through some more of these comments. Now, one of the links, of course, is so one of the things we want to cover now is just some of the questions that we're getting. I've been trying to monitor these well, and the chat line's been great because some of you guys are jumping in and putting your own thoughts, and obviously everyone's here trying their best to come up with solutions that may or may not have the straight answers yet. But I'm just going to go to the questions that have come in, and one of them, Jordy, is this whole idea of someone else signing your will for you. And maybe you could talk a little bit about that and where that might come in our practice.
Right. So the Succession Law Reform Act allows the execution of a will by a testator. I'm just going to pull that up if you can give me 1 second.
Absolutely.
And can you see my screen still? Yep. Okay. Yep. So it's section 4. And it's right here, 4A, and it says that the will is signed by some other person in his or her presence, so in the testator's presence, and by the testator's direction. And so this is allowed. So in other words, if the testator was typically used, the only time I've used it in my career is where I had a testator who didn't have the physical capacity to sign, to move his arms. And so the testator can instruct another person, in this case instructed me, to sign the will for him, in other words. And that is valid under 4.1 sub A. And it's clear, in my view, that the emergency order contemplates the presence of also being by video. So let's take this scenario. The testator has a copy of the will, and the same identical copy of the will I'm sitting with as a witness. And on video, he instructs me, we're in each other's presence, he instructs me and directs me to sign that will for him. I think that part does satisfy 4.1A. And then I've got a wet signature on the will because it's mine. And we're actually, as Ian knows, we're working on a blog about this very issue right now. But so now I sign it on his behalf. And I can also, the case law suggests that I can also be one of the witnesses. So now I do that in the presence of, and then I have the other witness there as well. Testator's in the presence because we've got us on Zoom. He can see us, we can see him. We subscribe to that will, and it is likely valid at that point if we follow all the other rules that we have. But it's as if the testator signed it right then and there, but I'm signing at his direction.
So that's an interesting creative step as well in this whole creative tools to get wills signed in this COVID environment. And you,
I think
as you say,
more of that, Ian, to be honest with you.
Sorry?
I think we're going to see a lot more of that as an option. Now, as a litigator, Ian, I'm sure you're going to have some questions about how those things are done, because you want to make sure that the testator knows that they're instructing you to sign the very will that they intend. And that's why I think if you're going to use that technique, that you identify that document very specifically, i.e. with a name and a date and a time, so that you can say, I am signing, you were directing me to sign, and then he's, the testator is looking at the same document or maybe showing him each page, et cetera, but identifying it. And then there's a special testimonial clause for that kind of thing. And an affidavit of execution for that kind of execution. But I think we're going to see more of that. And if everybody can stay tuned till tomorrow, we'll have some more resources on that process and other, not only comments, but resources as well, because other documents and other drafting is required.
Right, and we'll have that, hopefully we're shooting for tomorrow to get that rolling. And Brad, you make a good comment on the chat that would you want the will to stipulate that it's being signed by and on behalf? And those are the kinds of questions that we're going to deal with in our checklist and precedent that we're going to add to our blog.
Right.
Okay. So we think that's a viable option that we want to at least have out there as an additional option to the, well, as a supplement, I would say, to the video option. Because the video allows us the presence of, and now we've got an option now to even make it a little easier, possibly, and we're just working through the mechanics of it. But this is moving legislation, and we think we're it's not easy to stay on top of all of it. Okay, so Jordy, the affidavit, sorry, the will itself that you've signed, just to finish that thought, what are you putting on the witness piece where the signatures are in the will itself? What is your statement on there? Have you changed it in the will?
Yeah, I think this typical testimonial clause may be fine because you are in the presence of the testator when they sign. They're in the presence of you when you sign, but you may have to amend it slightly depending on your circumstances. I would also, as I think mentioned, putting the date of the witness's subscription to it, inserting that, and yeah, so.
That's great. So Ian Levine, you made a good point too. He's noting that the SLRA does provide that the person signing at the testator's direction cannot be a beneficiary. So that's a helpful comment. Powers of attorney, let's turn to that because there are some, I would say, some tweaks and some considerations, different considerations because of the legislative differences. Perhaps, Jordy, could we spend a few minutes just on the execution of powers of attorney with this new video legislation? And I see you're calling up, you're ahead of me on the answer.
Yes, so just give me one moment. I'll just pull up the checklist. It's very similar. POA, I mean, the big difference, right, is the restriction on witnesses. And this is one where, quite frankly, I've once ran afoul of it only to discover it in a panic in the middle of the night. But so under a will, of course, one of the witnesses can't be a beneficiary or, well, shouldn't be a beneficiary or the spouse of a beneficiary, or else they're going to lose their gift. But a power of attorney, the two witnesses can't be the attorney, the spouse or partner of the attorney, the grantor's spouse or partner or child, excuse me, and not under guardianship. So, you just have to make sure that you're not one of the named attorneys in their power of attorney. If that's part of your practice where you might be named as an alternate or something like that, you can't be a witness. So just, that's something just to note, and we've put that in the checklist. Similar guidelines for the execution of a power of attorney. The history on execution of a power of attorney is not as fulsome as that of a will, but it's generally considered to be the same type of provision. And I'm just going to call up, if I can here, Substitute Decisions Act on my screen, and I want to just go to the execution provision, which is here on paragraph 10, and it says it shall be executed in the presence of two witnesses, each of whom shall sign the power of attorney as witness. So it doesn't specify exactly the manner, but we typically consider it to be done in a similar way. And so I would follow a similar path for the execution of the power of attorney as that I did, and for the will. But we don't have the idea that a grantor can give authority to someone else to sign. at their direction. So I'm not, I think it's riskier for sure to do it with a power of attorney than for a will, because the will legislation, of course, permits it, and the power of attorney legislation, the SDA, doesn't specifically allow it.
Yeah, and I think that's the big difference there. And so if you're going to go to the trouble of setting this up and you're doing wills and powers of attorney, the direction to someone to sign for you on their behalf for the power of attorney, I think is risky. And you're going to have, now they have substantial compliance provision, of course, but the difficulty is, as you've highlighted, the difficulty is that's a subsequent step. And also one of the earlier points in the chat was, these documents have to be, especially powers of attorney, have to be vetted by third parties such as banks. So every step that you go outside of the box in terms of what they're comfortable with and what they're used to puts your documents a little bit more at risk. So powers of attorney actually in some ways are more of a problem than wills. They're, even with the video signing right now being legislation, how broadly understood it is going to be to third parties such as financial institutions is still a question mark. But we got to do the best we can in circumstances of a pandemic. Okay, so we're just, if we wouldn't mind, Jordy, could you go back to the, sorry.
I just want to pose a question that just is coming to my mind is, is it a good idea that we are, dating wills or putting dates of witnesses that they're signing on the will and changing the, if the testimonial clause applies to what we've done, why are we changing it? It makes it more, as long as it's correct, and I think the testimonial clause is correct based on the legislation. I think that the affidavits of execution will explain the dates that things were subscribed to and witnessed. And I'm just coming to this right now. Actually, I'm flying, on this right now. But should we be doing that? And maybe what we should just be doing is doing it the way we normally do it. We're going to probate this will. They're going to need an affidavit of execution one way or the other. And why put all that in there as long as we have the evidence? And I'm just throwing that out for people to think about. Sometimes we lawyers, or I should speak only for myself, but we go around trying to put all the information in that we can. As long as it's valid, as long as there's evidence that it was executed properly. Do we need to put all these red flags on things that may not be necessary? Just throw that out.
Yeah, I think you're right. And I guess that comes back to the only real, if you leave the testimonial as it is, then the big question is the debate. And that is the date of the will itself. And we've seen some interesting chat, I think drafting, and we're hearing some stuff on the chat line as well that deal with the dates of in the affidavit of execution, deal with the explanation there. That is where the vetting goes on by the registrar in common form circumstances, right? It doesn't, the vetting doesn't go by third parties in terms of the will itself. If you get probate and it has passed through the registrar in common form, then you have met it and you've explained it through your affidavit of execution. So
I wonder
if
it's not just creating more red flags for everybody. I mean, because of course right now I did a lot of wills, not a lot, but I did several wills in my backyard, properly executed the same way we used to do it, with social distancing, but in physical presence. I mean, that continues to be an option for in some situations. And so, I'm just wondering if we're going too far to put too much stuff into the will, when, as long as the testimonial clause is accurate, do we need to go further? Anyway, I throw that out for food for thought, and maybe we'll come back around to that at some point.
All right. I guess one of the things that I'm just looking at the chat here, the emergency order was passed. It it's valid until the end of the emergency measures. So it's live, and it's not a short-term scenario. All right. So from your standpoint, Jordy, I just wondered if you wouldn't mind coming back to that resources list, and if you could talk through just for a moment some of the highlights so that people can see what's available. We've spent a lot of time in the last week and a half pulling this together. It's an organic document. It'll be updated on our webpage, but it's a document I think of some use. But maybe you could spend a moment running through it.
So this is the Law Society's resource list, right? This is from the Law Society of Ontario that they put together with input and posted with, people have asked me on social media about, there's no practice direction or anything else. This is the best. I don't know if we're going to get a practice. It's not the Law Society who that gives practice directions, but some idea of what to do. But I think this is what has been put together, and there's a lot of resources out there about dealing with these things. I'm partial to yours, Ian, but a lot of people have written about this, and as you've said, that you have the resources, the checklist, the affidavits of execution, and things like that. And it's nice that the Law Society has endorsed at least that list. So.
And the Law Pro Avoid a Claim link has just been put up, which is helpful too as a resource in terms of where this goes. All right, Sarah, I know you're on this, and I'm happy to have you just take a moment maybe and just jump in with the project that you're involved with to announce to the group briefly what's involved and what people may or may not want to help with.
Hi, good morning, everybody. My name is Sarah Auld. I work with Finlay Lawyers in Hamilton. We have recently, in the last 2 weeks or so, put together a group of lawyers who are doing pro bono wills and powers of attorney for frontline COVID workers. So anybody who's on the front lines, really, in the medical establishment, paramedics, nurses, doctors, custodial staff, anybody who reaches out to us. We're not wills and estates specialists. So doctors and nurses who have reached out to us have some fairly complicated situations. So we are doing all the sort of standard stuff. And thank you very much to Jordy and Ian for making the eState Planner software available. It's wonderful. It's a wonderful program. But we are wondering if there are some specialized wills and estates practitioners that we may be able to refer some of these people to on a pro bono basis to do the more complex stuff that we just aren't comfortable with. We will not overload anyone. We will not overwhelm anyone. The stuff that's coming in is coming in kind of slowly, but we're seeing more and more. And we're just wondering if there's anyone else in the group who would be willing to help out with people who have complicated situations on a pro bono basis.
Thanks so much, Sarah. So maybe if you could put on the chat a link to you and if there's people on this chat today that can help, please do. And we're all doing our best for an unbelievable part of the community that is the heroes for sure.
Certainly, I'll do that right now.
That'd be great. Thanks, Sarah, for jumping in. Okay, so Jordy, I know you we're just getting close to our hour time, and I just wanted to check with you on a couple of questions that came up in the last note here. And Andrea, thanks for the Frontenac Law Association, the Kingston area has a pay what you can plan for pro bono as well. All of these efforts are tremendous, and anything we can do to support that, we want to do it. Just one question here, Jordy. Is it possible to get the will couriered from the testator to witnesses on the same day, and then you probably don't need to make any alterations to the affidavit as long as the witness is a licensee? That's another idea and another suggestion.
They still need to identify that they were a licensee and it was by video conference, I think. But yeah, I mean, I think it's going to be a big business for couriers for sure.
Absolutely. All right. Well, look, I know you've just, while we were on that, talking with Sarah, you've been looking at some of the resources. We got a few more minutes here. Do you want to just tell me what you're looking at here and what you wanted to talk about?
So this is LawPro's Avoid a Claim blog. Useful for sure about how we're going to avoid avoid claims as we can, and how to lessen your risk of malpractice. We have all we're focusing right now on execution. Normally, we barely think about it. I think we can sometimes be so concerned about this execution now that we neglect other areas. I think it's very important that we're vigilant on other areas. And the number one cause of claims that LawPro will point to for wills and estates is inadequate investigation, unlike any other area, right? So that means and communication. So the client not understanding what you're saying, or that you're not understanding what they're saying. Those two massive percentage of the claim. Whatever you can do to avoid that is going to, be important now more than ever. And I think we're going to see the communication issue bigger. I think I encourage everybody to do what they can to make sure that you're investigating the same way, or as close to the same way as we had before, asking probing questions to test capacity. But not only that, more importantly, the idea that that you're probing questions about asset ownership and people in your family and things like that, and that the communication is a two-way street, that they're understanding what you're saying, and that it's very, for those of you who are doing phone interviews only, it's very challenging, very, very challenging. And to do a phone interview, if you can use Zoom to help you with that, it's really going to make a difference, I think, to be able to see that, at least have that interaction with the client in a visual way, and making sure that they're understanding what you're telling them and that you're understanding what they're telling you.
Well, that's great. And it's just, while you're there on the links page, Kim Whaley has gone and created a really helpful tool for video conference instructions and testing undue influence. And there's a link to her checklist there. I think I hopefully got you the most up-to-date checklist, because it should be on there. But if it isn't there, it's on Kim Whaley's site, and we're going to add it to this. I know I've asked to get added to, but it may not have got added to the version I've sent you. So it will be updated. There it is. Maybe it's no. Anyway, no. Oh yeah. Anyway, we'll get that added. Sorry, I was looking at that last night, and it was a really excellent tool. Oh, there it is. There, try that one. All right. There's the link anyway to it. So we'll get the checklist, the actual checklist. That's to her blog. Okay. So I think thanks very much for the nice comments that are coming through on the chat line. And I think
I just like to say, Ian, that yeah. I hope, I know all of you recognize leaders in the profession. Ian Hull has been remarkable in this, and without him, we wouldn't have any of this. And I commend, he's a good friend of mine, but I just think we all owe you a huge debt of gratitude for the work that you're putting in on this. It's wonderful. And anyway, I just wanted to thank you.
Jordy, thank you. You're the guy who's doing all the technical work and keeping all of the detail and keeping me on the straight and narrow. So between the two of us, we've been able to get some progress, and we're going to keep getting progress, and we're going to stay on top of live issues. So we'll keep doing our weekly seminars. Next week, we're going to be focusing on the off-site intake and some of the actual tangible tools that we've been using, so that people can see what we're doing if it's of any help to them. So thanks for taking time this morning on a Saturday. We wanted to get out as quickly as we could on this important legislative change. So we'll announce our next one for next week, and hope everyone has a nice long weekend.
Stay safe, everybody. Take care.